Hi, this is Erica Merrill, and I am the founder of Perfect Legal Video, and I am very excited to have with us today attorney Nicole Reeves Lavallee. She owns a family law firm out of Worcester, and she's absolutely amazing. And she comes on here and talks about so many fantastic topics that have to do with family law and sometimes even real estate. Today, we're going to be talking about family law, and we're going to be talking about modifications to agreements. And I want to welcome you today, Nicole. Thank you so much. We're looking forward to learning all about when things need to change.
And that's a big job to cover, and when are we going to change it and how are we going to change it and what it's going to look like is always one of those questions that I get, and it's just not a simple answer.
So I get it, because people think that once they've gone through sometimes a year or more that it takes to get a divorce, or maybe it's not even getting a divorce. Maybe it's just some kind of a childcare situation that they want ironed out and they're not even married. I mean, there's a lot of agreements that can be modified. And once you get them done, it's so much blood, sweat, and tears. You think, oh, phew, that's it. I'm all set. And then somebody disagrees, or they decide they don't like it. So can you tell us what kind of cases would allow a modification?
So you kind of summarized it, so good job for you. So any case that has a judgment in family and probate court can be modified. So it may be a paternity case, it may be a complaint to establish paternity, it might be a complaint for custody support visitation, it may be a complaint for divorce that's modified. So there's various different types. You can also modify a guardianship. So anything really in the family law realm that has a judgment can be modifiable with certain exceptions, but a lot of things that are going to be dealing with children are going to be the things that you're going to be looking to modify.
And it's always the toughest when it's the children, isn't it? You really want what's best for them, and some of these decisions take forever. Can you tell us, when is it okay to even ask for a modification?
It depends on what you're seeking to modify. So if you're looking for a child support modification, that's probably the easiest one to define, because if there is a change in either party's income, if there is a number that, look, I was getting the child support, but the child support is revamped, or I lost that job and now I'm making $2 more an hour, and as a result of that, the child support number would be different than what I'm getting, that's pretty much an automatic. So there's a rule that basically says, hey, if there is a number that is not in conformity with the child support guidelines, I can go back into court and I can ask for a modification. Now, just putting it aside, is there are certain things that says if you never follow the guidelines, that may not apply. Just something to be aware of. But otherwise, you're going to have issues pertaining to, simple things. Maybe it's health insurance, maybe it's life insurance, maybe it is the parenting schedule, maybe it's the holiday schedule, extracurricular activities. So there's a lot of things we can cover, and we can even cover college education. So those are a lot of the different areas that we can talk about, and obviously it depends on what's happened now versus what is happening at the time of the divorce. So certain things may or may not be changeable immediately. Some things may have to require certain things. So the general rule in a modification is that there must be a substantial material change in circumstances. What substantial material change looks like really depends on your case. It's not something that I can just define without knowing the facts at the time of that final judgment and the facts today. It's a very hard thing to define, but when I hear it, I certainly know whether it's a warranted thing to file a modification or not.
Well, I mean, and that's an interesting point you bring up about the change in income. How do you even know if there's a change in income? I mean, do you try to check it out every once in a while? I mean, it's not like everybody is sharing their tax information anymore.
Well, that could be. So it depends. Sometimes in judgments, a lot of times in judgments of divorces, I will put a clause in there that says both parties are going to exchange their respective financial statements and their W-2s and their 1099s every year on a date certain. In that particular case, you would know, wouldn't you? Obviously, for the most part, you're going to know if your spouse changed jobs. They went from Stop and Shop to now being a corporate manager. Okay, great. That's probably going to result in some kind of money increase. There's going to be changes when I lost my job. Oh my God, I don't have any money. So those are going to be the obvious changes. The day-to-day, hey, look, I've been at the same job for the last 5 years, and the spouse will always say, I'm making the same amount of money, go away. That's always going to be the response. But again, if you kind of think that's the case, then yeah, you probably don't qualify. But maybe there's other circumstances, such as a change in parenting schedule, and you go, well, while we're addressing the parenting schedule, maybe I'll ask for the child support, and maybe you look at the child support and you go, okay, it didn't change. So it's not something on your own that you would want to do just the child support if you don't believe somebody got a raise. You know, they went from an associate in a law firm to now being the senior partner. Okay, they're making more money. But again, I got my hourly raise because I work at a minimum wage job. Really probably isn't going to have that much significance. So really looks at that type of job and where they have moved in that field.
I know that there's a lot of variances if someone is an entrepreneur and they own their own business. I mean, that can go up and down like crazy. I mean, we both own our own businesses. We know that some years are better than others. In those cases, would you check on it every year, do you think?
That was definitely something that I would want to put in an agreement where the parties are going to exchange that yearly, because we don't know. We don't know if it's going to go up or down drastically. We don't know if it's going to be the same. Obviously, okay, we had a pandemic. So is that going to change it? Well, it might. But again, did we bounce back from that? So we kind of have to look at the big picture on some of these things. That is probably the hardest one, because unfortunately, when you own your own business, I don't know that your numbers are accurate. That's a little bit harder to disclose and to figure out whether or not the person who is providing those tax documents is even being truthful. So it's something that, again, as an attorney, we really have to eyeball it carefully.
So how long does a modification typically take once you have put one in action and you know that it's going to go your way?
So once I don't know that you know it's going to go your way, but once you file a modification, then basically it's on an 8-month track. So from beginning to end, it should resolve itself within 8 months. Now, again, right now, most cases are 8 months to a year. That's a general rule. They really do try to keep it to 8 months when we're back in court full time. But I would say 8 months to a year is probably a reasonable time frame.
Well, that's good to know. And I had another question about, you know how sometimes people can have frivolous lawsuits and you can sue someone for looking at you funny. I'm just wondering if there are situations where people are asking for frivolous modifications and they're wasting everybody's time and money. Are there any restrictions on filing modifications to avoid those types of situations?
Initially, no. There's no way for us to know that it's going to be frivolous. So generally speaking, the court will entertain things. When I have seen this happen is that it's the same person filing for the same action over and over again. And those are the times where, generally speaking, I can ask the judge to say the clerk or somebody from the court has to approve the filing of a modification. And 99% of the time, it's always pro se litigants, because, hey, they're doing it for free and they can do whatever they want. And their whole job is to make your life miserable, and you're paying an attorney. So they think they got the leg up. So when you have this situation and you have the clerk literally have to review the documentation, you will have to talk to that clerk and tell them exactly why you think you can file the modification. And in my experience, when it gets to that point, modifications don't get filed anymore. I've now gone on 2 or 3 of these for probably 3 or 4 years without a modification, where literally before it was every 3 months. So usually the judge will give you 1 time, maybe 2 times. After that, they will absolutely enter an order that says, nope, the court has to find something before you go into court. Obviously, the other thing is they can order attorney's fees, but again, they're going to look at circumstances, and a lot of pro se's, they're not going to get their hands slapped for the 2nd or 3rd time.
Now, what if your ex ends up marrying somebody else? Does their income combine with the other person's income? Is that a reason to ask for a modification?
Not really. A lot of times people will think that unless that person that they're marrying is now going to take care of all of the expenses of the household, or they're a millionaire, in which case, we're living in a different place and we have this extravagant lifestyle. Generally speaking, it's not going to have an impact. It's one of those things that the court can look at, but that alone is not going to change a child support order.
So when we're looking for this information, where do we look in an agreement?
If you have a divorce, and this really only pertains if it's a divorce case, but if you have a divorce, you want to look in the very first sections that nobody ever reads because everyone thinks it's legalese, and it is. There's a section that always says merger or survival, and that's the paragraph you want to look at. So if it merges, then it's modifiable. So M&M, that's how you kind of remember it. Merge is modifiable, and everything in terms of children is always going to be modifiable. And that's why you don't have it in paternity or custody cases, because it's always modifiable, because the only thing is the children. Same thing in a guardianship, you're always going to have that. In a divorce, you have obviously division of assets as well. So what does that say? So a lot of times you will have merge as related to children issues and health insurance, life insurance, alimony. So if you haven't waived future alimony, that's something that the court can take a look at and can modify at a later point in time if the circumstances warrant it. Again, health insurance, because the health insurance is going to be pertaining to not only the children, but also can be pertaining to the ex-spouse. Life insurance, again, we're going to be looking at that in terms of paying alimony support as well as child support. So again, something that can be modifiable, and we want to take a look at on those issues on a case-by-case basis. But those are the general issues of what is going to be modifiable.
So this is a question that you didn't plan for, but I'm just wondering, once you have something in writing and your agreement is signed, we've talked about these modifications, are there any strategies that are kind of dirty tricks that people might use to pay less later, or change things up?
I'm never going to give people dirty tricks, so let me start there. But the reality is, yes, there's a lot of them that a lot of people that use. The biggest one is, again, now I've learned that, hey, look, she can look at my bank account, so I'll put it in somebody else's name. Those are kind of obvious. I have a house now, I'll put it in somebody else's name. So it's a lot of that. From my perspective, what you need to do if you're seeking a modification is going to be simply, what can I show? How do I show it? So whether it's documentation you need or a log of, this is everything that has transpired. So my kid is coming home crying hysterically every day, saying that she hates mommy because she's doing this, or she's drinking this white bottle that's from the freezer. Those types of things that you kind of go, oh, I know what's going on here. And so you want to, as a parent, want to keep a log of all that, so that you can better your case. But in terms of the tricks for people that are not being reputable, that's exactly what they are. And the reality is that always comes to light. So one, I'm never going to tell you to do that. Two, most importantly, that's going to come out, and that's not going to be taken lightly by the judge. And so again, you're going to be in a situation that if you're doing that, there's going to be severe consequences.
Oh yeah, and I wasn't asking you for the dirty tricks to do them to people, just more of along the lines of what to look out for, because so many people are litigious. So many people decide after they've made the agreement that they'd love to renege on it, but there are rules for at least a certain amount of time on that. So just wanted to see like what you should look out for in the future if you are happy with your agreement and you don't want people trying to change it through unsavory means, let's say.
Yeah, I think the biggest thing is always, be vigilant. Know what that agreement says. Know that you can enforce that agreement at all times. So even if there's something that, hey, I veered from it and we kind of did our own little thing, know that you can go back and you can enforce those terms to the strictest sense. So there are things that you can do to protect yourself, but again, from my perspective, just make sure that you keep a log of everything, because it's going to be your best friend. It's very difficult to say, hey, well, for the past 5 years, we've done this, this, and this. Do you have any records? Oh, no. Because the other party's saying the exact opposite. And then it becomes a he said, she said match, and that's never going to be beneficial to you.
And another thing I'd love to ask you is that, like, what do you do if somebody isn't adhering to the agreement? I mean, I've heard of people that have kind of let things slide because they don't want to rock the boat, and then it just gets to a point where, well, now X, Y, Z has happened. It's not just one thing anymore. And now when they go to court, the judge might be like, well, why wouldn't you come to us when the first thing happened? I mean, what are your thoughts on that?
Well, again, it goes back to the agreements. Most of the agreements are going to have language in there that says, hey, the parties are allowed to ask for strict performance. That's the language that you're going to be looking for in that agreement. So it means, yeah, we can come to an agreement otherwise. We can act like adults and reasonable human beings, and we can compromise. The court wants you to compromise. But when you're compromising each and every week, at some point, the court's going, hey, you set a new precedent. This is the new rules. This isn't what you're doing anymore. So you have to kind of look at that and go, is this going to be a one-time, two-time thing? Or is this going to be an every week decision that we're now going to change? Because if you are making that change on an every week basis, then guess what? That person that's now getting those new changes is going to run into court and say, I need a modification. And the court is going to go, well, what have the parties been doing? Oh, exactly that? Okay, well, why don't we grant that? So it's something that you need to be aware of, that yes, you can ask for specific performance, but the question is why and what types of rights are you giving up? So again, if it's just, hey, we want to swap out Christmas Eve, I know it says I'm supposed to get even years, but you can have even years from now because I had another child and my husband has that scheduled with somebody else. Okay, done. Nobody's going to care. But again, if it's something like, hey, you only get an every other weekend time, and now I'm giving you 5 days a week, guess what? At some point, unless you can show, hey, look, I was taking care of my sick mother during COVID for 3 weeks or a month, what's your reasoning for doing it all that time? And that's what the court's going to look at.
Yeah, I mean, it's super tricky too, because I have heard of people just saying, oh, I'll take them for an extra day for you. I'll take them for an extra day. And then all of a sudden they take them back to court. They get more custody or visitation rights. And then the parenting time, sorry, I know we have a specific thing we call it here in Massachusetts. And they're also petitioning for more child support because they're going to have the child more. And it may not have been, something that you really planned. You just thought that person was being nice. And now all of a sudden you've lost time permanently with your child. And I've heard of people doing that in other cases too. It's like, oh yeah, just a verbal, you can take them out of state, and then they get arrested because they took their kid out of state without written permission.
Yes, although the opposite end of that is I took my kid out of state with permission, whether it was written or not, and they've been gone for 6 months, and then you go, no, I want them to come back. Now you lost jurisdiction. So it's something that you need to understand what your ramifications have.
Well, that is really scary. It's really scary. So, I mean, what would you suggest in those situations? Should you just always set a precedent where people put things in writing?
That's an understatement. My life revolves around writing. So yes, unequivocally, everything you do should be documented. Again, it's something simple like, hey, can you take, the child because I really have to go to this, this meeting, I have to get this land, this contract, and I really can't find a babysitter. Go ahead. Great. document that. Okay, I understand that I'm taking, my child for this date and this time, and we're doing it because of this reason. Say that. There's absolutely nothing wrong with saying that, because most of the time I was going to go, why are they asking me that? Of course, sure. And the point is, now you have a record. You have why you were doing it. You have theoretically the duration that you were doing it for, and you have the specific reason. So it's something that you're going to be able to hang your hat on if you have to go into court on it.
Well, this has been such great information and so interesting. Is there anything else you'd like to share with us before we go? Any stories or things we should watch out for?
I think the biggest thing that people don't understand, to kind of leave it out there for you, is, when do I get alimony? I didn't waive future alimony, so when do I get it? And that really has to be looked at in terms of, what does the situation have? If your children are grown, maybe you're more inclined to get alimony. If obviously your spouse won the lottery and is a millionaire now, then probably. Again, those are things to look out for. But general rule is, you're not going to be able to get spousal support or alimony and child support. So I think that's the hardest thing, that people don't understand, when they can get it and why they can get it. And of course, the other end of that is, I am getting alimony, but how do I get it terminated? And again, we have to look at either the statute or the rules in their separation agreement as to when to modify and when to terminate alimony. So I think those are probably the hardest things that people don't understand. And I get a lot of calls on of going, how do I fix this? Can I fix it? And you need to know what your rights are.
Absolutely. And I mean, if I can give anyone any advice, it would be to absolutely call Nicole if you have any questions at all, because it's always better to get your questions answered now while you're going through something than to wait a while, think that it's okay to put it off, and then the situation is either unfixable or it's just not going to come out to any kind of outcome that you were looking for. And you might even be blindsided by something. So always ask questions if you can. They are fantastic over there at Reeves Lavallee, and they just treat you like family. So I want to thank you so much for coming on and being so giving with your information. I know this helps a lot of folks out there, and we really do appreciate it.
Good. Glad you enjoyed it, and hopefully you learned something.
Absolutely. We'll look forward to talking to you next week. Have a great day.